Good afternoon. I'm Angelica Spanos, and this is the Law and Crime Report, where we are diving into true crime and all legal stories making headlines today. First up, new details from the Jeffrey Epstein investigation. More than 10 years ago, then U.S. Attorney Alexander Acosta resolved the sex crimes of Epstein through a non-prosecution deal without telling any of Epstein's victims. Well, now a Justice Department investigation re-looked into that and says that Acosta showed poor judgment, but did not find that Acosta and other prosecutors involved committed professional misconduct. Senator Tim Kaine from Virginia questioned Acosta. Let's listen.
The opening that I read suggests that you decided as U.S. Attorney to cut a non-prosecution deal, that part of the decision was that that non-prosecution deal be held private, not appear in the public record. And there's an allegation that I just read that you did not pursue a federal indictment, even though your staff had advocated that you do so. Is that accurate?
That is not accurate. Let me address the, one of the difficulties with matters before the Department of Justice is that the Department of Justice does not litigate in the public record or in the media, and litigates in court. Let me set forth some facts. This matter was originally a state case. It was presented by the state attorney to the grand jury in Palm Beach County. The grand jury in Palm Beach County recommended a single count of solicitation not involving minors, I believe, and that would have resulted in 0 jail time, 0 registration as a sexual offender, and 0 restitution for the victims in this case. The matter was then presented to the U.S. Attorney's Office. It is highly unusual, and as I was speaking to some of your colleagues that have been involved in prosecutions, they mentioned that they don't know of any cases personally where a U.S. attorney becomes involved in a matter after it has already gone to a grand jury at the state level. In this case, we deemed it necessary to become involved, and we early on had discussions within the office.
Okay, that was Tim Kaine questioning Acosta during this investigation. With us today to break all of our topics down, we have Rossi, former federal prosecutor, as well as legal analyst here on Law and Crime, and Dina, another one of our legal analysts here on Law and Crime. Gene, I'll come out to you first. Virginia guy, along with Tim Kaine. I'm sure you're familiar with him questioning Acosta during this. What do you think about the findings here?
Well, first off, Tim Kaine is a very good friend of mine. I live in Virginia. He is one of my senators. All I can say is this, Angelica. Mr. Acosta was not truthful under oath before Senator Kaine in that committee. It is a total fabrication that the line prosecutors did not want to go forward in his office. That's falsehood number one. Falsehood number two is, based on my experience, on my wall, I have a case involving a crooked pain doctor where the Prince William, Stafford County, Virginia, had indicted a doctor. It was set for trial, and I took over the case in the U.S. Attorney's Office. He is absolutely incorrect that the tail wags the dog. A federal prosecutor can take over a case from the state at any time, and it's done every day of the week. So the third thing I want to say is he said that this was like a harsh sentence. There were 30, 40, 50 victims. If they had gone federally, Epstein would have gotten life under the sentencing guidelines. So I can't even watch his testimony because it's so disingenuous.
And with this story, this was obviously more than 10 years ago, now brought back to light because of obviously how Jeffrey Epstein was arrested more presently in New York. When you have something like this that's being revisited multiple years old, what's the challenges here for, in this case, the Justice Department?
Oh, for the job. Well, here's the thing. It's hard to be a Monday morning quarterback when you're reviewing the game, not the next day, but several years later, to draw a football analogy here. But in reviewing this, the Office of Professional Responsibility, it was challenging. But I'm telling you this, Angelica, this is a relatively straightforward case in the sense that you had a predator, Jeffrey Epstein, who was engaging in alleged sexual acts with underage women. And the investigative techniques are very straightforward. You talk to the witnesses, you talk to the prosecutors. Even though it's been several years, the investigation by the Justice Department was not that hard, relatively, because it's a lot of evidence that you would talk to witnesses and things like that. It's not a fraud case or anything like that. So to answer your question, I think the Department of Justice, Office of Professional Responsibility, did a good job. I don't think there was bar violations. I do think they violated the victim rights statute by not consulting with the victims. So that, I guess, would be a potential area of misconduct. But in terms of making a decision not to take the case from the state level, that's just bad judgment.
All right, Gene, thanks. Dina Dahl, coming out to you. What are your thoughts on, the fact that there was no professional misconduct here?
I agree with Gene that this whole thing, I think that they should have actually charged him with misconduct. I mean, here we have Epstein, who is accused of child rape and sex trafficking. These victims are the most vulnerable in our society. And the prosecutor's job is to take these kind of cases to defend our victims, right? Like the judge and jury is impartial. The defense has its own attorney. If the prosecutor does not stand up for victims and prosecute these kind of crimes, those victims have literally no voice in our criminal justice system. So, it was interesting. The Justice Department in their review of it said, well, since then there's been so many more victims. And as if somehow that meant at the time he wasn't culpable. We know there was plenty of victims back in 2008. But that statement to me just revealed how damning it was for Acosta not to fully prosecute that case, because there were so many more victims that Epstein had afterwards that could have been prevented if he had done his job as he should have and fully prosecuted Epstein at the time.
All right. And President Trump also weighed in on this during the investigation. Let's listen to that and what he had to say.
Made a deal that people were happy with, and then 12 years later, they're not happy with it. You'll have to figure all of that out. But the fact is, he has been a fantastic Secretary of Labor. And Alex called me this morning and he wanted to see me. And I actually said, well, we have the press right out here, so perhaps you just want to say it to the press. But I just want to let you know, this was him, not me, because I'm with him. He's a tremendous talent. He's a Hispanic man. He went to Harvard, a great student. And in so many ways, I just hate what he's saying now, because we're going to miss him. But please, Alex.
I have seen coverage of this case that is over 12 years old, that has input and vetting at multiple levels of the Department of Justice. And as I look forward, I do not think it is right and fair for this administration's Labor Department to have Epstein as the focus rather than the incredible economy that we have today. And so I called the president this morning. I told him that I thought the right thing was to step aside.
All right, Dina. So there we have the president as well as Acosta. They're talking about this after this ruling was made. One of the things about this case is this is something that has come up for a while. This incident was many years ago, but of course, new findings with and related to Jeffrey Epstein have really been coming up regularly, if you will. And even when he was arrested in New York and now that he is dead, do you think that this is the last we're going to hear of all of this with Epstein, Dina?
Well, definitely not, because as we know, Maxwell, his associate, is being prosecuted right now, and a lot is going to be revealed during her criminal trial, not only about her, but also about Jeffrey Epstein and perhaps other people as well. So this is not the end of it. And, it is too bad that we heard President Trump talk about this, because it just erodes the credibility of the prosecution's office. And it's why some people, anytime you politicize the justice system, people lose credibility in it. So not only are people questioning, hey, Jeffrey Epstein, we know, had a lot of money and a lot of power, and how come he was treated like this, when really almost any other person with this kind of crime would not have gotten such a sweetheart deal. And then on top of it, we hear the president of the United States weigh in. And the unfortunate thing with all of this, as I said again, is here, these victims are the most vulnerable in our society. And we need people to look at our justice system and not see it as only for the rich and powerful, only if you're connected to a high political office, but that the justice system is going to work for you. And anytime we see any politicizing of it, it harms people's faith in our system.
Absolutely. And Jean, going off what Dina said about, how this changes people's opinion and credibility of these type of investigations when, someone like Epstein gets off like this.
Well, what this case shows me is the powerful and the rich are treated a lot differently. And this whole thing about a non-prosecution agreement, let me call it like it is. It's immunity. A non-prosecution agreement is immunity. He didn't even get a slap on the wrist. He was saying, we're not going to deal with you. I have never seen in my 27 years with the Department of Justice an alleged predator like Jeffrey Epstein preying on teenagers 13 and 14 years old, for which they had a boatload of corroboration. It just wasn't her allegations. You had documents and diaries that corroborated what they say. I am ashamed that this prosecution agreement, non-prosecution agreement, was approved by the Department of Justice. And there is no way the line prosecutors agreed with that decision. No way.
All right, Jean Rossi, Dina Dahl, thank you both. We're taking our first break right now during the Law and Crime Report. We'll be back after this with plenty more of today's top stories. Stay with us.
Chief Schroeder is today initiating termination procedures against Louisville Metro Police Officer Brett Hankison. Unfortunately, due to a provision in state law that I very much would like to see changed, both the chief and I are precluded from talking about what brought us to this moment or even the timing of this decision. I know that you will have questions, and I'm sorry that I cannot answer them because of the state law, ARS Chapter 67C.3261F.
All right, welcome back. That was Louisville Mayor Greg Fisher. He was announcing the termination of one of the police officers involved in the fatal shooting of Breonna Taylor. Well, that same police officer, we now know that he is being charged and accused of sexual assault. We're talking about Brett Hankison, and he's now being called a sexual predator. He's being accused of assault and battery. This story is really interesting because obviously this adds a second layer here to the whole Breonna Taylor murder case. An incident which is described in a lawsuit, it says that Hankison volunteered to drive a woman he knew home from a bar and invited himself inside. The woman allegedly says that he sexually assaulted her when she was unconscious and sleeping. She woke up and he immediately left. The lawsuit also states that there are claims from 9 other women. There are internal reports, and it alleges somewhat of a cover-up by other officers who knew of his conduct but never reported it. So Jean Rossi and Dina Dahl with us. Jean, this is really interesting because, as I said, this is something that these officers are already kind of in hot water, if you will, because of Breonna Taylor's death. And now this, what's this all mean?
Well, this gets to an issue that I'm involved in one of my cases that I can't disclose. In the police departments, they have internal affairs files. And in those files, and evidently former Detective Hankison had 50 internal reports involving his conduct. 50. not 550. Those internal affairs files, those professional responsibility files, they are usually kept sealed, and that is what the mayor of Louisville was talking about. They are almost always sealed, and you never know what happened. And what bothers me about cases like this is I think it's the plaintiff, Miss Borders, has now come forward on an allegation. And is this something that's consistent, that is occurring in those 50 files that are sealed, or is this just one isolated incident? If it's consistent with what happened in those 50 files, they should be unsealed. They should be made available to the public. There should be transparency. Now, the police are going to fight that as hard as heck because they want to protect the police. But it always troubles me that there are internal affairs files with misconduct, and then the police are promoted, they're reassigned, they're given slaps on the wrist, and eventually you'll have a Breonna Taylor incident based on conduct of officers that probably should not be wearing a badge.
Interesting. And Dina, we have this lawsuit that's come out, and then separate from this is the fact that there are a handful of officers charged in Breonna Taylor's death. And we know that they're going to be tried together, and that's, again, separate from this. But how did these two things overlap, and how is this going to lead to a fair trial ahead?
Yeah, there are so many lawsuits involved with this. So quite a few cross complaints, essentially, with a police officer and Breonna Taylor's boyfriend. And when I read about this case now, I just see this as an example of why justice delayed is a bad thing. Because this happened, we know Breonna Taylor was killed way back in the spring, and it took months for any charge to get filed. And then there was all this mystery, dispute around the grand jury proceeding. And I think it reflects the anger and frustration of the community and feeling like justice wasn't served. And then there being a scrutiny on everybody involved and wanting to make sure that there was no other wrong that was left kind of unaddressed. And so each kind of wrong is being addressed in turn here, which makes everything so complicated, not necessarily wrong, but is what is keeping the national attention on these particular officers.
Right. And, with this instance and a lot of these other crimes that we talk about in the headlines, sometimes you almost think that the resolution of these is a statement on the dialogue surrounding them that's going on nationally. And I think in this case, this is similar in that, because you have a sexual assault charge here with someone who's already been labeled a bad guy. And now it's almost like, well, we have to make this guy a bad guy too in this case, because he's already associated with doing something else incorrect.
Yeah, and that is the harm, right? Because he could have been wrong in that night and in the shooting, but not necessarily sexual predator, or vice versa. It is true, kind of like Jean said. I mean, this claim, when I first initially was reading about this claim, you don't ever know. There's like he said, she said, but it sounded like there were quite a few other claims of that he was exonerated about, but other women did come forward. In one instance, he was claimed to have requested sexual favors in order to not criminally charge a woman. I mean, that's a very serious claim that some woman did come forward with. He was exonerated of it. But when you see multiple times women coming forward with these types of claims, you start to believe that there is something behind them. And that if there were so many claims, even if he was exonerated, why was he still on the force? Is there like that bigger conversation of maybe allowing too much misconduct within a police officer's file and allowing them to go forward? And was that the case? Maybe he was not bad in that sense, but maybe there isn't a strict enough kind of like ethical standard around police officers in general.
Right. All right, Dina, Jean, thank you. I'm going to switch gears right now because we have another story I want to talk about. Following a settlement with several Muslim women, the New York Police Department will now allow religious head coverings in booking photos. The policy stems from two separate lawsuits filed back in 2018, where 4 different Muslim women claimed that their civil liberties were violated when they were forced by officers to take off their hijab in front of men during their booking pictures. And hijab is a religious headscarf that's typically worn by Muslim women, and it covers their head and their neck, but not their face. This is an interesting story here. Gene, coming to you first. What do you think of that?
I want to compliment the New York Police Department and all parties here. This is a phenomenally positive and productive resolution. And I was just looking at the statistics. The NYPD is 47% white, 29% Hispanic, 15% Black, 9% Asian. I'm sure it covers every religion you can think of. And I think this gives me a lot of hope, because one of the complaints I have is that the police departments at all levels, federal, state, and local, they don't have the sensitivity to the cultural and religious and community needs that then they should have. And this shows that they're raising their level of sensibilities. And here's the punchline. It's going to build trust between the police department and the community if they show more sensitivity to people who are arrested. And just because you're arrested does not make you guilty, and you should not be treated like you're guilty. So this kind of draws that compromise. There are a lot of exceptions. If there's a tattoo or contraband that's hidden in the garments or anything that's worn, they have a right to remove it. But for just pure booking photo purposes, I think this is fantastic.
Absolutely. And as you said, Gene, once you're charged, that does not mean that you're found guilty. Dina, the good thing about this, piggybacking off what Gene said, is this will likely set a good example moving forward. And the NYPD is extending this to other headwear related to other religions, like yarmulkes, turbans, and wigs.
Yeah, I think it's also a great policy, and it really makes a lot of practical sense. Like Gene said, there's a lot of exceptions. If they feel like they need to remove it to get a better investigation, they can. But the reason why it's not necessary is because hair can change, right? I mean, somebody can cut their hair, somebody can color their hair. We change our hair. So hair in itself is not necessarily the most important identifying feature of somebody. And it's the reason why U.S. passports already allow people to cover their hair, and why driver's license in a lot of states already allow it. So I think this is a great policy because, one, it doesn't impede really the gathering of information that the New York Police Department needs. And it sends a single signal that, hey, we hear that your civil rights are important and we are standing with them. And I think that's great.
All right, Dina, Gene, thank you both. We're going to take a quick break. After this, more headlines of the day coming up. Stay with us. All right, welcome back to Law and Crime. Florida Governor Ron DeSantis has drafted new legislation that's a step closer to allowing citizens to shoot looters and rioters if they are targeting businesses. The move comes as an expansion to the state's Stand Your Ground law after months of protesting that led to rioting this summer in Florida. It is aimed to prevent violent and disorderly assemblies. It's an interesting thing we have here. We want to listen now to actually, I apologize. We don't have sound on that. We're going to discuss this with our guests. Gene Rossi and Dina with me to talk about this. This is out there, right, Gene? I know you wanted to talk about this over the break. Yep. Let me know what you think about this new move by DeSantis.
Well, I just looked up in Google. There were two movies, Death Wish in 1974, and then the remake of Death Wish in 2018. Charles Bronson and Bruce Willis. And it's about a surgeon whose wife and daughter were brutally attacked. They survived, I guess. And then the surgeon took the law into his own hands and started killing the alleged perpetrators. This takes it a step further. This allows business owners to take the law into their own hands, become vigilantes, if looters are destroying their property. And I think it's a slippery slope that will be a luge, because if you allow business owners to kill people to kill people and to shoot people if their property is being destroyed, then that changes a lot of common law, a lot of statutory law. I think it's a bone. I think it's a bone that Governor DeSantis is throwing out there to win some political support. That's my cynical view.
Well, you mentioned, we mentioned the stand your ground law, and this kind of takes that step further. But where can we look into the law for the answer on how this could play out? It's not a done deal yet, obviously. It's still in the beginning stages. Is this even possible legally to come to fruition?
Well, I think you'd have maybe a constitutional problem. You'd have a due process problem. You can't pass a law that allows people to just kill people at will. That's number one. This is not at will, but a business owner, if their property gets looted, they get protection by the law and they can kill somebody. You're violating the due process rights of the person who will be killed, as I read that law. And I've never seen a law proposed like this. And I think it's just a treasure trove of problems for the victims and the police and the community at large. If you got gunslingers and vigilantes who are trying to take the law into their own hands, it's terrible.
And Dina, as Gene touched on, this is something that's not exactly cut and dry. There's a gray line here that could easily get blurred. What are your thoughts on this Florida move by DeSantis?
I was thinking that it constitutionally could not be upheld for a little bit of a different reason. I mean, the law specifically states that if there is an assembly nearby, an impairment of a business, then the person could kind of like stand their ground and shoot somebody. So it is tied to an assembly. And in our Constitution, we have the right to assemble. So I think that actually impairs the person's right to an assemble, because there is putting like some sort of a restriction on it. Because why should it matter? I mean, if he's going to pass this law, then maybe why not just say the business owner can always do this? But instead, this law specifically is called an anti-mob law. It specifically says if there is an assembly within 500 feet, then the person, and I don't even know if it's just a business owner, I think it could be anybody, could then kind of defend an impairment of a business. But because it's tied to an assembly, I think that is a really strong argument for it not being constitutional.
I
All right,
agree.
we'll be keeping our eye on that. And go ahead, Gene.
Oh, no, Dina, thank you. You brought up, I didn't even think about that. She's taking it to another level, like was Emil, take it up a notch. But I'm thinking, what if you have 500 people 500 feet away that are completely peaceful? They're singing songs, they're lighting candles, and there's some yahoo unrelated to that assembly who says, hey, I'm going to take advantage of that, and I'm going to break this glass window and get the jewelry. Okay? Dina's right. It could impair the First Amendment right to assembly. It has no relationship. It could be overbroad.
Yeah, and it's interesting because in a lot of these instances, you see a couple people kind of leading the charge, but there's always these crowds around people. There's journalists there. There could be, younger kids that are just kind of there to watch and see what's going on, especially today. We have so many people gathering during these times, and it's unclear of who's doing what and where. So it'll be interesting. We'll be keeping our eye on that story for sure. I want to switch gears right now because we have new developments in Ahmaud Arbery's alleged murder. Arbery was jogging back in February when he was confronted by Gregory and Travis McMichael. Arbery was fatally shot 3 times during this encounter. More than 2 months later, the father and the son duo were arrested, as was a neighbor who filmed the death. Well, the pair just appeared in front of a judge during a bond hearing on Thursday. The judge is considering their request for bail, and they also asked the judge to toss out 2 of the counts against them, one being malice murder. They said that they were charged in a legally flawed indictment. The pair have been in jail since their arrests back in May. We know that at the hearing, the defendants brought character witnesses forward. We also heard from the victim's mom. So let's listen now to Greg McMichael's wife.
Ms. McMichael, how did you feel when you discovered that your daughter had posted a picture of the scene on her Facebook page?
Horrified.
Why?
And disgusted. It was a bad judgment call, and she has been tormented and harassed ever since.
How did your husband, Greg McMichael, feel about what she did?
Objective speculation.
Had you and Greg discussed how he felt about what his daughter did?
Yes.
And what did he convey to you?
He was furious.
You were asked whether your husband was about to be fired from the district attorney's office. Will you let us know why that is not the case?
Because we had planned retirement a year in advance. He had a retirement date already set. My husband did not have arrest powers that last few months. So what he did was he worked in the office between the police department and in Camden and the DA's office until he retired. He never arrested anyone anyway in his duties.
Do you know whether a DA investigator even has to be a post-certified officer?
I don't think so.
All right. And so do you understand that this was an agreement that he and his boss reached for him to finish out the year that he wanted before he retired?
Absolutely.
Had you ever heard from his boss or from him or from anyone before Mr. Evans the phrase, instead of being fired?
I never heard that before. He planned his retirement.
The neurologist, tell us about the stroke. As his wife and being intimately familiar with it, and as a nurse, what did that stroke do to him?
He's got a little bit of memory loss.
What part of his body did it initially hit?
It hit his. There was really initially no signs, but then he woke up and he could not see out of his, I think it was his right eye, part he could see.
And is that what the neurologist told you, where it was impacted?
He had a stroke in the eye itself.
All right, so that was Allison McMichael, the wife of one of the defendants, as well as the mother of the other defendant here. Gene, this is another interesting story here. Listening to this and knowing what you know about this, because this has been a big story since May when they were arrested. What do you think? You think they're going to get their bail?
No. And here's why. I think it's Mr. Bryan did not get bail, and he is the least culpable and the person against whom they have the least amount of evidence. And if he didn't get bonded, I doubt that Travis and the father, Greg McMichaels, are going to get bonded out either. You know, when you do a bond hearing, there are two things you got to look for as a prosecutor. Is there a risk of flight? You prove that by preponderance, or danger to the community. I don't think either one is going to be satisfied by the defense or defended against by the defense. They committed an alleged murder, and they both have reason to flee because they're facing serious charges. I don't think they're going to get bonded.
And what are the grounds, do you think, for them being able to deny that?
The judge, the things that a judge will look at a bond hearing is the weight of the evidence, the nature of the charges. We have murder. Is there a reason for them to flee? You got a stiff sentence that they could possibly face. I don't know if they're seeking a death penalty, but those are things that weigh against release. And a judge may set a high bond value that the defendants can't even meet, even if he does agree or she agrees to bond. The judge may set a high bond value so that the defendants can't possibly meet it.
All right, Gene and Dina, I want to get your opinion on this as well. What do you think about this new info about this?
I agree that because the third party, William Bryan, was denied bond, then these two probably will not. And it is true that it was possible that they could have all had bond. And when you saw Derek Chauvin and the police officer with George Floyd, he received bond. I mean, a $1 million bond, but he did receive bond. So it wasn't impossible. But the fact that the third party, the least culpable person, didn't receive it is a good indicator that none of them will. And I know that they did argue that, you know, at least the father in particular has saved lives in the past with his Coast Guard duty and I believe it was military service. So, you know, they are trying to argue that they are not such a threat to the community that, and then the wife was being a character witness. But because I don't know if the prosecution, but they were planning on putting forth evidence of, you know, racial comments that they'd made online and to show that they were a continuing threat to the community. So between that and the fact that we know the third party didn't receive it, I think they'll remain in jail also.
Angelica, I have to get off.
All right, Dina, thanks. Gene Rossi.
Have a great weekend.
Yeah, I was just going to sign you off. Gene Rossi, thanks for joining us today. Always a great time to have you on.
Bye, Dina. Bye-bye.
We're going to take a break
everybody.
as well.
Good to see
When
you.
we come back, we'll have plenty more coverage here on Law and Crime. All right, welcome back. We're going to continue talking about the McMichaels as well as Ahmaud Arbery's mom. His mother spoke at the hearing, and she basically gave an emotional victim impact statement where she pleaded to keep her son's alleged murderers behind bars. Let's listen to what she said.
Contacted my attorney on the behalf of Lynn County this past spring during the course of the GBI's secondary investigation. They discovered what they believe to be one of Ahmaud's bone fragments near where he was murdered in Satilla Shores. They wanted to know what we wanted to do with those pieces of my son that they were still discovering in the streets. I have sat here and I've listened to the attorneys for both Travis and Greg McMichael. They tried to explain that their clients believed that my son was a trespasser. On that bright Sunday afternoon, as he ran down the streets, he was somehow engaged in a criminal enterprise. Their defense is summed up in an idea of grabbing their guns, chasing, boxing my son in with the vehicles, pursuing him, and eventually shooting him to death, ripping his body into pieces. And that was the right thing to do. That, if given the opportunity, both men would do the same thing again. These men are proud of what they've done. And they want to go home because in their selfish minds, they think that they're the good guys. And I and my family is left literally to pick up the pieces. As the court may imagine, I have suffered. I continue to suffer mentally and emotionally while I wait for justice for my son. My daughter, Jasmine's older sister, Jasmine Ahmaud's older sister, his best friend, just had her first baby. I often think as she begins the journey of motherhood, will I have the words of wisdom to help her along the way? Mothers protect their children. I wasn't given the opportunity to protect my son. I'm here to ask this court to help me be a mother who protects my grandchildren and fight for justice for my son. He ran this path many times, and our home was just a light jog away. But for him, no matter how he maneuvered, no matter how fast he ran, or how quickly he turned, these men refused to let him go home. They should not go home now to prepare for their defense, to enjoy their children and grandchildren, and to be embraced by the community. These men are as dangerous today as they were on February the 23rd of 2020.
All right, so that was the victim's mom there giving that powerful statement. I mean, Dina, this is really a good example of an effective victim impact statement. I think it was really, really not only emotional, but really resonated well there.
Absolutely. I thought she did an excellent job of really being the voice for her son, which is her point. I mean, the judge heard a lot of evidence from both sides, and she's giving him a chance to really, feel the impact that it had on her family. And her description of how much her son tried to run away and how much he was trapped by them, I thought was excellent, because it really went to how dangerous they were. Because you couldn't really argue that there was some self-defense on their part, or even if they had suspected him of stealing something. I mean, it had to have been evident that there was nothing in his hand when they kept trapping him. They got very close to him. So I think that really showed how callous, how kind of horrific the killing was. And I think that really lends to the fact that they should not be roaming the streets, that they should be behind bars. So I think she did an excellent job, not only of showing the emotion and the loss of her, but really how calculated the crime was in that moment by them.
And going forward, what's next in this case? I mean, this is obviously one of the steps here until this does go to a trial, likely, right?
Yes, exactly. This is going to go to a trial, and we're going to hear, we've already heard so much about this through the press, but there could still be more details that are uncovered as this goes on. And again, we just talked about the DeSantis Florida law recently, and this kind of came to mind because in essence, this is what these people were doing, right? They thought that he was stealing something from their neighborhood, took it in their own hands, and decided to kill him because of it. And we are sitting here, I would think most of us, horrified that somebody would kind of claim that mantle of authority to be able to kill somebody just because you're suspecting them of burglary. And then here in another instance, we have the governor of Florida wanting to pass a law essentially saying that this is okay. And so I hope that the fact that these stories, we're actually talking about them so close together, we can see how dangerous that Florida law is and what that would say about our society. Are we going to allow a killing like Ahmaud Arbery to happen? Is that really going to become legal? It's an interesting juxtaposition that we're talking about the two right now.
Absolutely. Our stories here on Law and Crime always intersect with each other. Dina, thank you. I want to just give you a quick update. On Monday, we're going to be starting live coverage of a new trial. This is a murder trial out of Ohio. Erica Stefanko is charged in connection with the murder of Ashley Biggs. This is the ex-girlfriend of a man that she was married to at one point back in 2012. Stefanko is accused of making a fake pizza delivery call that lured the victim to a business, and then she was killed. Police said that the ex-husband, Chad Cobb, ambushed the woman, killed her and strangled her. This all happened, again, back in Ohio. We're going to be covering that trial starting on Monday. He has already pleaded guilty and sentenced to life in prison. We'll have more of that. Stay with us.